In today's video, we are going to learn about some of the introduction regarding new criminal laws, the 3 new criminal laws. So overall, in all the videos, we'll be covering the history, introduction and the important dates and the few terminology, advantages and disadvantages, and how do you study these acts, the bare acts explanation, and the prelims and mains coverage, and also the tips and tricks to remember all these new criminal laws. So in this video, we'll be covering a very short scenario regarding the introduction, so that before starting these bare acts, this can help you with the introduction strategy. So talking about this origin of these new criminal laws, there have been lot of reports from the year 2003 onwards regarding that there should be some significant reforms which should take place in the criminal justice system, and this has been recommended by Malimat committee in 2003 in their report. And looking into this incident of 2012 Delhi gang rape incident also, the Verma committee highlighted that the justice system require the reforms which especially look into the protection of women. So apart from this, the origin in history, whereas the parliament has brought up these 3 new criminal laws and introduced on 11th August 2023. Also, there is a drafting committee in the parliament which has been looked into this bills which have been introduced into the parliament. And on 12th December 2023, these bills have been introduced into Lok Sabha and they are passed in Lok Sabha on 20 December 2023. Whereas they are passed in Rajya Sabha on 21st December 2023 and received the President assent on 25th December 23, and they finally came into force on 1st July 2023. Also, the law commissions also plays a very important role in introducing these new criminal laws. So before understanding these new criminal laws, let us understand few terminology which have been used in the bare acts. So these terms make us understand and recognize what are actually the meaning when they are referred to particular section and clause. So you come across the terms amended, added, omission, substituted, repealed, and many more. So let us see these few terms before. So amended, the term amendment is something that the changes have been made to particular bare act sections or chapters or clauses. So it can be any of it. So what this exact amendment include? So amendment can be of different types. So those types are addition or omission or substituted. These are the types of amendments which happen in bare act. So addition means to add or to insert something new. So they are bringing up something new section or a new chapter which is not in existence already. So that is called as addition while you are referring to this bare act language. So whereas omission is something that certain words are removed or certain sections are removed. So in a legislative drafting, you also refer to this formally as repealed. That means it is no longer in force. Substituted means there is one thing. Suppose there is section 2 already, and in section 2, in place of that, there comes the meaning of section 3. That means you have substituted something in place of the other. So that the word is called as a substitution or substituted. So look into these terminology so that you understand while referring to this new criminal laws. So before going into that, what did these new criminal laws have brought to our India regarding this introducing of these laws? What are the advantages and what are the disadvantages faced? So looking into a broader spectrum, the advantages are there is greater deterrence against crime, and there is incorporation of technology and digital evidence has been introduced, whereas decolonization and modernization have been looked into. So talking about these acts, the old acts are said to be referred from the British colonial era. So whereas this modernization of these acts have the term Bharatiya. So it's referring to a country. So whereas it also balanced the state security and individual rights, and its main focus is on victim-centric rights and to support the victims. It also streamlined the entire legal structure, and it also improved the police accountability. So, talking about the disadvantages, those who are preparing for different legal exams or judiciary exams, whatever it is, it's a big drawback for them, as they have to change immediately the reading pattern and the syllabus pattern from the old laws to the new laws. So, it's very challenging from them. The implementation challenges and the workload, the public awareness, and there can be a misuse of certain provisions. The advocates face a difficulty in interpreting these new statutes, and there can be a very much caseload of burden regarding these in the courts, and also the judges and the court staff need some extensive training regarding all these new criminal laws. So these are the advantages and disadvantages, or the pros and cons regarding the new criminal laws. So let us look into a comparative table to understand. So IPC, the old law before, has 23 chapters and 511 sections, whereas now referred as BNS Bharatiya Nyaya Sanhita has 20 chapters and 358 sections. So now talking about Criminal Procedure Code, back then has 37 chapters and 484 sections, and now Bharatiya Nagarik Suraksha Sanhita BNSS has 39 chapters and 531 sections, whereas Indian Evidence Act back then has 11 chapters and 167 sections, and Bharatiya Sakshya Adhinayam BSA bill now has 12 chapters and 170 sections. So don't think that okay, here 167 sections are there, so right now 170 sections, that means only 3 sections are added. No, it's not like that. What all the old sections are there, they have been shuffled. That means in old laws, suppose if section 2 has some explanation, in new laws the same explanation is not under section 2, it has been changed to section 4 or something. So there have been changes in the entire sections, that means the shuffled explanation, and there also been addition of new sections, and the numbering has also been changed, and there is also deletion or omission of few sections which have been repealed. So look into all those, and we will be stating all those in a clear format in upcoming videos as well. So before going into that, let us understand how do you study these 3 new Bail Acts. So this is very challenging, right? So in an exam point of view, because in student point of view, I am not talking it, because where this students have joined the legal or the law subject, that means the law course, LLB or whatever it is, right now, this new batch, it will be easy for them, so that they'll start with a new pattern of studies. They are not studying, they have not studied the old laws. But while regarding to the exam pattern, people who have already attempted the old laws, it's very challenging for them to shift back to the new barracks, right? So for this, what process are you picking up? So the main thing is you have to have your own process or strategy, which you have to look into, like how do you remember these things in a very clear way. The second thing is you have to have a very much comparative table between the old laws and the new laws. So that is where you can easily remember. When there is some particular topic, a important topic, you have to refer to the old section and as well as remember the new section. So you have to have a comparative table and look into the Bail Act reading. Give a line-to-line Bail Act reading, because you're not only covering for prelims this time for 2025 exams, you're also covering for a mains also. So both prelims and mains play a very important role in the judiciary exam, and you have to go line to line and start from the very beginning. In the exam point of view, is your first understanding. Prepare your own notes framing from your understanding regarding these new Bail Acts, all the 3 Bail Acts. And 4, mock test. Practice multiple MCQs regarding these 3 new criminal laws, and also derive the question and answer pattern from the previous question papers as well. Suppose in the previous question papers, you are having a lot of questions from this 3 criminal laws, right? Of course, 60 to 70% of all the exam patterns cover criminal laws only, mostly. The rest will be the remaining part of the syllabus. So whereas the 60 to 70% of the syllabus which you have covered for the old laws and you have written the exams, take your previous year question papers and for only pick the new criminal laws, the old laws, and for every question which has been given in the old criminal law referring to the old criminal law, try to write the answer format in the new criminal law. That means you have to remember the new section or some addition, whatever it is there to that particular section while you are referring to the new criminal law. So referring to the previous year question papers which are having old criminal laws as a questions and writing the answers in perspective of a new criminal laws which have come into force. So this is one way of pattern of your practice so that you get strengthened up with the main concepts of this criminal laws. So hope you like this video, and in coming video we will be covering subject wise prelims and also the mains part regarding these criminal laws. And also few important sections explanation also will be given in the coming videos. So don't miss all these videos. There'll be like a part 1, part 2, part 3 scenarios. So watch from the first till the end. And also we are launching few materials regarding this criminal laws. So the link will be given in the description below. So you can go to the link and view whenever there is a new material or a practice mock test or for MCQs which will be released sooner basing on the prelims point of view for this criminal laws. So you can purchase them by joining the channel and looking into the updates. Hope you like this video. Thank you.